The defendant demanded one thing. Let me face my accuser. For 200 years, courts said no. Then one Supreme Court ruling changed every criminal trial in America forever. And it started with a recorded police interrogation that should never have been played to a jury. August 1999. Olympia, Washington. Michael Crawford stabbed a man named Kenneth Lee. Crawford claimed self-defense. He said Lee had tried to rape his wife Sylvia just hours before. When police questioned Sylvia separately, her statement contradicted key details of Michael's story. She never testified at trial. The prosecution simply played her recorded police statement to the jury. Michael Crawford was convicted. But here's what the jury never considered. Michael never got to cross-examine his own wife. He never got to challenge her words. He never got to face his accuser. And this violated a right written into the Constitution 200 years earlier. The question that would reach the Supreme Court was devastating in its simplicity. The Sixth Amendment is just 44 words. But one phrase changed legal history. In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. The Founding Fathers wrote this in 1789. They remembered British courts where anonymous accusers could destroy lives. They remembered Star Chamber trials where defendants never saw the evidence against them. So they guaranteed something radical. Face-to-face confrontation. But by the 20th century, courts had created so many exceptions that the right barely existed. Prosecutors routinely used statements from witnesses who never appeared. Dying declarations. Excited utterances. Prior testimony. Business records. The exceptions swallowed the rule. Defendants like Michael Crawford were convicted by voices they could never challenge. If this is blowing your mind already, drop a like. The story gets even more twisted. Now let me put this in perspective. Imagine being accused of a crime. The prosecution's key witness never shows up. Instead, the jury hears a recording. A statement made to police. Maybe taken under pressure. Maybe taken out of context. Maybe completely wrong. And you cannot ask a single question. You cannot point out inconsistencies. You cannot look that person in the eye and demand the truth. That was Michael Crawford's reality. His wife Sylvia had given police a statement that contradicted his self-defense claim. At trial, Sylvia invoked spousal privilege. She refused to testify. So prosecutors did something clever. They argued her statement was admissible anyway under the state's hearsay exceptions. The trial court agreed. The tape played. The jury convicted. But Crawford's lawyers saw something prosecutors missed. Crawford's legal team appealed. Washington state courts upheld the conviction. They applied a 1980 Supreme Court test called Ohio v. Roberts. That test said hearsay was fine if it had adequate indicia of reliability. Translation. If a judge thought the statement seemed trustworthy, it came in. No confrontation needed. But Crawford's lawyers argued something revolutionary. They said Roberts was wrong. They said the Sixth Amendment meant what it said. The right to confrontation wasn't about reliability. It was about procedure. It was about the adversarial process. It was about looking your accuser in the eye. The Supreme Court agreed to hear the case. And this is where everything changed. Because one justice was about to write an opinion that would overturn decades of precedent. What happened in that courtroom shocked legal scholars across the nation. But that's not even the most shocking part. Justice Antonin Scalia, one of the most conservative justices in Supreme Court history, wrote the majority opinion. And he demolished the reliability test completely. Scalia looked back at English common law. He examined centuries of legal tradition. And he concluded that the Confrontation Clause was about one thing. Testimonial statements. When the government collects statements to use as evidence, the defendant must have the chance to cross-examine. Period. No exceptions for reliability. No judicial discretion. No workarounds for convenience. Scalia wrote that the framers would not have allowed admission of testimonial statements of a witness who did not appear at trial unless he was unavailable and the defendant had a prior opportunity for cross-examination. This wasn't about trust. This was about rights. If you want to see how this transformed every courtroom in America, make sure you're subscribed. The Crawford decision dropped like a legal earthquake on March 8, 2004. Prosecutors across America panicked. For decades, they had relied on hearsay statements. Victim statements to police. 911 calls describing crimes. Forensic reports from lab technicians who never testified. Suddenly, all of this was potentially unconstitutional. Police departments had to completely redesign their procedures. If they wanted statements to be admissible, they needed live witnesses at trial. Defense attorneys celebrated. Finally, the Constitution meant what it said. But here's where it gets complicated. The Supreme Court didn't define testimonial clearly. Lower courts scrambled to figure out what qualified. Was a 911 call testimonial? What about statements to doctors? The chaos was just beginning. And the implications would reshape American justice for decades. And this is the legacy that matters today. Before Crawford, approximately 40% of domestic violence cases relied primarily on victim statements to police. After Crawford, prosecutors had to get victims to testify. Some called this a disaster. They said abusers would intimidate victims into silence. But defenders of the decision pointed to something fundamental. The Constitution exists to protect the accused. Even when it's inconvenient. Even when victims are reluctant. Even when prosecutors want shortcuts. The right to confrontation isn't about making trials easier. It's about making them fair. Michael Crawford eventually pleaded to a lesser charge after his case was remanded. But his legal battle ensured that no American defendant would ever again be convicted solely by a voice they couldn't challenge. 200 years after the founders wrote those 44 words, their meaning was finally enforced. The Crawford decision has now been cited in over 10,000 federal and state court opinions. It remains one of the most significant criminal procedure rulings in modern history. And its principle is simple. You cannot convict someone with words they cannot challenge. Today, when prosecutors want to use a recorded statement, they must either produce the witness or prove the defendant already had a chance to cross-examine them. The ghost accusers of the past are gone. The Confrontation Clause finally has teeth. But legal scholars still debate the edges. Every year, new cases test what testimonial really means.